number 54, Aybar versus Aybar. Counsel?
Good afternoon, Your Honors. May it please the Court, my name is Jay Breakstone, and I represent the plaintiff appellants in this matter. As a matter of housekeeping, I will reserve, with the Court's permission, 3 minutes of my argument time as allotted for purposes of reply.
You have 3 minutes, sir.
Thank you, Your Honor. Your Honor, this case involves an automobile accident that occurred in the state of Virginia in a New York registered vehicle in which all the occupants were also New York residents. The driver was licensed in New York, and among the plaintiffs there were 3 wounded and 3 who died as a result of this accident. The defendant's auto was a Ford automobile. Ford is resident in Delaware. Its place of business is Michigan, and has been registered to do business in this state since 1920. The tire involved and the allegation...
I'm sorry. Counsel, are you still arguing that even under Daimler, jurisdiction's proper over Ford in New York State without forget the registrations?
Yes, both Ford and Goodyear. And that jurisdiction is because of the fact that both corporations were registered to do business and chose and consented.
But only on that basis, not that they're at home here in some other way.
No, not that they're at home under Daimler,
Okay.
under any of the 2 choices that we have to define that term.
Thank you.
Just finish that sentence. You said registered to do business and consented to...
Yes, and consented to jurisdiction in the state of New York as part and parcel of that registration.
So where in the relevant statutes that we need to review is a corporation advised that registering to do business and designating an agent for service of process it has a corporation consenting? Where is that, sir?
That agreement, that contract, for lack of a better term, was part and parcel of the registration process, the agreement to register, the act of registering, based on the case law since 1916, set by Justice Cardozo in Bagdon, affirmed by the United States Supreme Court in Nearbo. Make no mistake, and these defendants don't make the mistake of believing, that that was anything but an agreement, a simple agreement, an agreement to be treated no better and no worse than a domestic corporation.
Are you saying that the holding in Bagdon creates some sort of contractual agreement to consent to jurisdiction?
That's precisely what I'm saying.
And
that's what Justice... I'm sorry, Your Honor.
No, that's what I was going to ask you. Where does Judge Cardozo tell us about the nature of the agreement in Bagdon?
Well, he says, Judge Cardozo, and the portion is quoted in my brief, says that agreement is a contract, or that contract is an agreement. And it's a true agreement, he says. There's nothing unusual about it. There's nothing strange about it. There are benefits to both sides. Both sides operate under that agreement. And Ford operated under that agreement since 1920, sometimes moving on both sides of the caption.
Would you agree that Bagdon was a case about service of process on an agent that was designated within the state?
No, I don't agree, with all due respect, Your Honor. I think that Bagdon is a contract clause case. I don't think Bagdon is a due process clause case. I think that's the essential difference here, and it's the difference that the Second Department refused to see. If it were as simple as that, the Second Department would have decided it on the basis of Daimler and on the trilogy. But that's not what the Second Department did. The Second Department said that New York common law would change as to in personam jurisdiction because of, and I quote this phrase, an evolution of in personam jurisdiction. So what we do is we have over 100 years of common law, uninterrupted, unaffected, both parties operating under that common law, under that nature and belief that this is an agreement. But the Second Department turns around and says, no, not law, ethos. Ethos. The ether has changed. The world has changed.
But counsel, honestly, I guess it's not the world so much, but it's a constitutional interpretation, right, has changed. So let's assume, and I understand the points made by my colleagues here, but assume Bagdon says what you say it said. I think the theory would be it's read in a certain way 100 or so years ago in a certain constitutional context. But we've done this, and again, in a different context, in a criminal law context. We had a statute, the constitutional landscape changed, a case called Epton, 19 New York 2nd 496, and we reevaluated that statute in light of changing First Amendment rules and came out with a different interpretation, applying our ordinary canons of statutory construction, constitutional avoidance, right? Why wouldn't we do that here?
There's not a need to. And in fact, after the most recent decision by the United States Supreme Court in this area of Ford Motor Company, talking about specific jurisdiction, which now sort of has an asterisk against it.
But you've dropped a claim of jurisdiction, I thought we just made clear earlier on, based on the changing landscape of the personal jurisdiction, right? Like, didn't you have a claim, unless I'm wrong, in the appellate division, that you had a separate basis of jurisdiction here under doing business?
I think there's a basis, I think there are two bases, both under the 14th Amendment Due Process Clause and under the Contract Clause of the Constitution. I think there are two bases here. I think that these defendants are subject to the jurisdiction of New York, both under the Contract Clause because of their agreement, and I think they're also subject to the jurisdiction of New York since the evolution, if we're dealing with evolutions in ethos, since the evolution of jurisdiction under the Due Process Clause after the most recent Ford Motor Company case. Because this is not a case of where we're looking to Ford and Goodyear for anything other than the relationship they have with the state.
I'm sorry, I just want to be clear on the position because I might have understood. In the appellate division, the court said the plaintiffs argue that New York courts have general jurisdiction over Ford because Ford has, quote, become woven into the fabric of New York state domestic activity. That seems to be an extra statutory basis for jurisdiction. Forget the registration clause. Are you arguing a separate basis for general jurisdiction?
If I understand Your Honor's question, and I think that discussion was not directed at trying to convince anybody that the other corporation was at home here in the current sense of the word. I think it was designed to show that these two defendants had become related and relevant to their conduct in the state of New York vis-a-vis this case. In other words, I don't know what else Ford Motor Company does. I don't know what else Goodyear does. But as to their relationship with this state, and the Ford Motor Company talks about, the fact that we're not talking about causation, we're talking about relationship to the state. Does the act they're being held for relate to the activities within the state? Under specific jurisdiction, Your Honor is correct about that. But what I'm saying here is that material is put in the brief because at the point that was written, we didn't have Ford Motor Company. This case has been pending a long time. And so things now have changed. Things now show, and the court obviously can search the record to pull that up, things now have happened in which we have two bases for these defendants to be held, both under specific jurisdiction in the Daimler sense of the word, in the trilogy sense of the word, and that's 14th Amendment, but also under their agreement to be treated exactly like New York corporations. If the court held any different, if the court threw Bagdon out the window at this point, and threw Justice Cardozo's opinion out and through the United States Supreme Court's affirmance of that concept in Nearbo, what we would do is create an Uber corporation. Domestic corporations could be held under general jurisdiction one way, but corporations like Ford and Goodyear, which are multinational, couldn't be held. In essence, they would have filed a paper saying, we want to be authorized to do business in New York, but we want to do it on our terms. We want to do it so we can't be reached under general jurisdiction.
But the point of
where the Supreme Court is now is that you have two places, potentially two, minimum one, where you can sue a corporation, where it's incorporated, and if it is not the same place, it's principal place of business. Domestic corporation, they're incorporated here, it's their principal place of business, you're going to get the same thing. How is a domestic corporation put in a worse position?
Well, because, and using these two defendants as an
Yeah.
example,
Yeah.
that as to Goodyear, they can only be sued in Ohio because their principal place of business is there, and that's where they were born, in the corporate sense of the word. Ford in Michigan or Delaware. So here's a New York corporation, here's a New York authorized corporation who has to be sued in Michigan, Delaware, or Ohio. A domestic corporation doing the same thing
Yeah.
would be sued only in New York. So we have created an Uber corporation that really can't be sued anywhere, even though when they agreed to be an authorized business in the state of New York, they knew precisely what they were doing. And they have never taken that away. They've never asked to leave.
Didn't they just agree to process of service?
Oh, no, not at all. It's much deeper than that. Much deeper than that. And I think Bagdon and Nearbo speak to that. They want to be treated the same way as a domestic corporation. And I think it's...
Don't we have to view Bagdon under Pennoyer, and once International Shoe shifted jurisdiction, we have to now view Bagdon in that light?
Well, we possibly could do that. I don't think it's necessary because I think we're talking about different causes, different portions of the Constitution. One is the 14th Amendment and one's the Commerce Clause.
But doesn't the
Contract
shift
Clause.
actually work in your favor? The point of International Shoe was to expand the opportunities to get personal jurisdiction, not to contract.
I'm saying it's in essence, Your Honor.
I mean,
it is-
isn't that what the Second Department really was trying to get to?
I don't know.
Perhaps reaching a different result, but that evolution post-Pennoyer that you see with International Shoe is to expand, not to contract. That's the whole point.
Well, in terms of what the Second Department did, and just a point on International Shoe, it interests me that, Ford filed the permission to transact business in the state of New York in 1920, but Goodyear didn't file until 1956, I believe. And International Shoe was in 1945. So there's no sense of being duped by time.
Why
It
is that
was a
relevant?
contemporary decision.
Excuse me. Why is that relevant?
It's just relevant. It's relevant, Your Honor, in the sense that it has been of benefit to corporations to file in New York and to be treated as New York corporations for business and economic purposes. It's the same it was in 1920 as it was in 1956, as it is today. These two
Well,
corporations
I
have
think,
asked
I
to
think
leave.
there's an assumption that any attorney would make that you would seek the jurisprudence that benefits your client. I think that
agree.
that would be true for every party in this action and every party in any action. That's just good lawyering.
I absolutely agree, Your Honor.
From our point of view, though, I think we have to start with how do we read Bagdon initially? Is it read in the context, as Judge Singa said, of the historical moment and the territorial jurisdiction of Pennoyer pre-International Shoe, or do we read it as the beginning of an evolution in general jurisdiction that became consent to general jurisdiction by registration, as some of the appellate division courts have done in New York pre this decision and pre-Daimler? And if we do, how does Daimler change that?
I think,
And
Your Honor, I'm sorry.
Let me just finish my thought. And because I want to ask you about one of the briefs that I thought was made some interesting points was the brief of the New York City Bar Association discussing that particular issue. I felt I learned something there. And I was wondering if you had had a chance to look at it and if you wanted to comment on it.
I will in a moment, Your Honor. I just want to answer your first question.
Sure, go ahead.
I think we have to look at Bagdon the way that it was written and see whether that...
When you say you want to look at Bagdon the way it's written, yeah, but
As,
what strikes me sometimes is you're divorcing it from its historic roots. And it's hard for me when I read that to say that Judge Cardozo was wrong. I just felt that he was writing it in the context of Pennoyer. First off, no New York State Court of Appeal judge is ever going to say Judge Cardozo is wrong. I want you all to know that. But the second thing is that none of us would be that presumptuous. But the second thing is that when he was writing it, the law was in a much different place than it is now.
If that were so, Your Honor, why would the present United States Supreme Court consistently throughout the trilogy of decisions that we're talking about put in the proviso, the disclaimer, that such and such is the state of jurisdiction without consent? That language is there for a reason, because consent removes those line of cases.
So let's say there is a question of consent. Wouldn't all parties benefit by an express consent in the statute?
Well, if there were a statute, but the statute stands no different than the common law in this state. And much is made, Your Honor, and in the city bar's brief, much is made of the legislative history, where the city bar was obviously involved. Well,
Counsel, can we try and maybe approach this consent idea from a different direction? A while back, the Supreme Court decided a case called the Insurance Company of Ireland, and they pointed out a number of instances that would be indicative of consent. They talked about choice of venue clauses in contracts, arbitration within the forum. I thought it was notable that nowhere in there, in a nation where all 50 states have registration statutes for corporations, they didn't mention registration as one of the indices of consent. Does that trouble you at all?
Well, no, because I think that we have such a clear statement of that in Bagdon and in Nearbo, such a clear statement that nobody can doubt what was done. And none of these defendants have said they didn't know precisely what it was that they did. And I think it's important when we talk about the city bar brief, is that if we take a look, as Your Honors know, there is new legislation that's been passed by both houses of the legislature, waiting to be sent to the governor. This passed on the last day of the term and is waiting for the governor to receive the bill. And that bill creates a statutory framework, precisely what Your Honor says, to reaffirm the fact that consent is there and that jurisdictions in the state of New York, general jurisdiction for corporations that choose to register. And what's really interesting to me is in that new bill, it is described, Your Honors, not as a statute of new law, but an explanation, a clarification of the statute of the old law.
Counsel?
And that's in the legislative memo.
Counsel? I'm
Yes.
sorry, counsel, here, over here.
Judge
I'm
Garcia.
sorry. Without seeing mouths, Your Honor, sometimes it becomes...
I know, it's so hard. But just this idea about international shoe as the kind of a pivot point. Supreme Court recently decided a case, Ford v. Montana, and Justice Gorsuch concurred in that decision. But he says, at the same time, the court in international shoe also cast doubt on the idea, once pursued by many state courts, that a company consents to suit when it is forced to incorporate or designate an agent for a seat of process in a jurisdiction other than its home state. Going on, it is unclear what remains of the old consent theory after international shoe's criticism. Some courts read international shoe and the cases that follow as effectively foreclosing it, while others insist it remains viable. Now, again, it's one justice writing or a few justices writing here, but doesn't that at a minimum plant the idea that ever since international shoe, this has been an issue? And I agree international shoe in some ways, in terms of specific jurisdiction, may have expanded opportunities. You have to look also at what it did with general jurisdiction and what happened with general jurisdiction over the decades since, so especially with Daimler. So doesn't that thinking, whether or not it changed or didn't change, but the questioning of it itself, make it our responsibility to re-examine Bagdon and its holding in light of those developments?
Well, Justice Gorsuch's comment. To the extent it's an invitation to talk and speak about it in an intellectual sense is probably fine. But it doesn't help us any here, because there were two out of the three trilogy of decisions before Justice Gorsuch got there, saying very specifically that we decide these decisions so long as there's not consent. And the reason for that is because the court did not want to battle the effect of the contract clause, sitting in Article 1, I believe. Now, I don't think there's any difference between amendments and the text of the original Constitution, but I can't think of anything that is more primary in the framers' minds than the contract clause. But it's interesting to me, Your Honor, when you mentioned Ford Motor Company, that if we looked at this case from if we did not decide, if we decided not to decide the contract issue, we looked at it just under the terms of Ford Motor Company, where would we be? We'd be with jurisdiction in New York. Ford Automobile, Goodyear Tire. Accident occurs in Virginia, of some importance, but probably not overwhelming under the restatement anymore. But you've got all New York plaintiffs. You've got defendants who we have specific jurisdiction over under Ford Motor Company. The opposite conclusion, were the court to turn around and decide there's no jurisdiction here, either specific under Ford Motor Company or general under Bagdon, is that these plaintiffs would have to litigate this case probably 3 times in 3 different jurisdictions. That can't be right.
But why wouldn't you have jurisdiction where the accident occurred?
Excuse me?
Why don't you have jurisdiction under Ford v. Montana where the accident occurred?
Can I answer that with another question, Your Honor?
No, I get to ask the question. So why not?
One might have it there, assuming that these 2 defendants decided that they were more finely attuned to the jurisprudence of Virginia than they were of the jurisprudence of New York. Because if not, Your Honor, we'd be doing this same dance in the Virginia Supreme Court. These 2 defendants only want to be sued, and they don't even want to be sued in the same place. One wants to be sued in Ohio or Delaware.
But I guess my question is, whatever they want, your position, would you have jurisdiction in the state where the accident occurred here over all the parties?
I don't think I could, I don't think that I could hold jurisdiction against these defendants based on your question. So I would end up litigating it in 3 different places. And remember, there's a third-party defendant who is the installer, U.S. Tires, coming up in another case. U.S. Tires is from Queens. That's 4 jurisdictions now. Ohio, Delaware or Michigan, Virginia, and the state of Queens.
Thank you, counsel.
Thank you,
Counsel?
Your Honor.
Thank you, Your Honor, and may it please the court. Sean Murata for Ford Motor Company. Let me start
with that point. Do you think he would have jurisdiction over all these companies in the site of the accident, the state?
There would be jurisdiction, I think, under the Ford Motor Company case over Ford and Goodyear in Virginia, yes. I think U.S. Tires might be its own kettle of fish, but they're not actually even a party in this particular case. So you could get jurisdiction over all the parties in this particular appeal in the state of Virginia, yes.
So can I ask you if you agree that jurisdiction by consent, can occur?
Sure.
Okay.
Absolutely.
So if this case were being litigated in 1940, is it your position that Bagnon would allow for jurisdiction by consent or no?
I think under Bagnon, under Pennoyer, under Pennsylvania Fire, under that regime, yes, there would probably be jurisdiction by
So that's
consent.
good, because that helps me then understand that your argument really is about the pivot that we've all been discussing from international shoe.
That's exactly right. I mean, plaintiff's argument is somehow we are denigrating the great memory of Judge Cardozo. We're not. Bagnon was a perfectly sound Pennoyer opinion. Under that framework, Bagnon makes perfect sense. The problem is when you have the pivot in international shoe. And it's a pivot that I think goes to the statute, and that goes to the Constitution.
Well, the reality is that that's not true. I agree with you that international shoe is a watershed. The pivot is the recent Supreme Court jurisprudence, because it is clear that that jurisprudence took us in a different direction. Even the main author, of course, Justice Ginsburg, rest her soul, recognized that there was very little case law from the Supreme Court on general jurisdiction, And so those are the cases that then shed a different light on what we understood from international shoe. So I'm not sure that I would say that all of a sudden international shoe means we're throwing away everything we understood before then. But I want to ask you about the comment I made to your adversary over here. Isn't international shoe, the takeaway from that, the watershed moment, is to expand personal jurisdiction over foreign corporations?
Absolutely. Specific,
Okay. So how is your position in line with that? If that is the core essence of the intent of international shoe, how is your interpretation that authorization and consent, authorization to do business and then getting you consent, as he argues it, is anything but in line with that core idea?
Well, what international shoe gives us is specific jurisdiction. And you know what Justice Ginsburg said when she wrote in Goodyear and when she wrote in Daimler for the court was that specific jurisdiction has come to the fore. Most cases now before the courts are specific jurisdiction cases. So, then it's separated out, specific and general jurisdiction. And, I think to get to a housekeeping note, there were 3 arguments that were before the appellate division: at home, specific, and registration. At home, the appellate division ruled against plaintiffs. They abandoned that argument in their opening brief by not making it. Specific jurisdiction, the appellate division found was forfeit in the Supreme Court because it was not made in that court. Again, plaintiffs haven't challenged that decision in this court. So all we have left is registration. And sure, specific jurisdiction is quite broad. Specific jurisdiction is how you get jurisdiction over Ford and Goodyear in Virginia, even though they don't build things, they didn't build these cars there, or they didn't design those cars there, and they didn't sell
any
those.
specific jurisdiction always opens you up to a change of venue anyway, but go ahead on that.
Absolutely.
So you might not end up in Virginia anyway.
What we have here is this old, outdated consent by registration, which is really what the courts were doing when they were struggling against the Pennoyer was very constricting. So what courts did was they came up with these fictions.
No, why, no, I'm not sure I see that. Why isn't it really more like Burnham when it comes to a natural person? That this is long in existence, you're in the state, you're served, that's personal jurisdiction. The state always has the opportunity to do that. And of course, a business entity somewhat being different than a natural person, if you agree to comply with the rules that are necessary to be authorized to do business, and you agree to service by an agent of the state, that's the equivalent to the tag jurisdiction under Burnham, very well established, everyone knows it, and that sort of addresses the concern. Why isn't it like that?
I don't think it's like that, because I actually think Burnham cuts in our favor. Justice Scalia's plurality opinion for the court in Burnham says, yes, the rule is tag for individual people, but it says, corporations are different because there are these artificial people, and you can't have tag jurisdiction on a corporation. And in fact, the Fifth Circuit
Right, but that's my point about the consent. Unless you're actually, unlike the tag, where the consent is fictional in this way, an individual may not really know that they're subject to this until they face the music. Lawyers and judges may understand it, but an individual may not. And yet corporations, right, they consent so that they can do business.
Well, I think that gets us back to the statute, which is I don't think there's really any consent here. I mean, if you look across the breadth of the business corporation law, there is absolutely nothing in it that would tell you that when you send in this form to the Secretary of State, that what you have just done is consent to general jurisdiction in the state.
But that's not necessary given the understanding and the jurisprudence, right?
Well, I think the understanding in the jurisprudence was...
the legislature could have corrected that if that's not what they meant, and they never did.
Well, I think there's 2 answers on that. First is that Bagdon is interpreting a different statute that has been the law in New York for decades. And as the New York City Bar Association brief and the Chamber of Commerce brief lays out in the drafting history of the business corporation law, to the extent you think it matters, what did the legislature have in its mind at the time it passed the business corporation law? It had research memos. It had research memos showing, 1, There are some states whose business corporation laws do address personal jurisdiction. 2, that under international shoe, that had abrogated the fictions of consent by registration. And 3rd, a lot of the drafting history shows that the back and forth about who do you serve, the Secretary of State, a private agent.
Let's say we don't agree with you on that, but let me ask you this. Do you agree that this question about whether or not registration gets you consent, valid consent, do you agree that that's an open question when it comes to the Supreme Court? The Supreme Court has not decided that issue.
They have never said Bagdon is overturned. I will give you that
Well, no,
much.
they did. No, I agree with that.
But I think when you look at the trilogy of, my friend talks about one trilogy, I have a different trilogy, which is International Shoe, Schaefer, Daimler, and BNSF. International Shoe says, we're repudiating the fictions. Schaefer says, International Shoe.
To the end of expanding jurisdiction. Go ahead.
Right, expanding this new world of
Yeah.
specific jurisdiction.
Correct.
Schaefer says, and it was looking at the old quasi-in rem jurisdiction,
correct.
and it said, International Shoe is really the paradigm now, and it has a footnote 39, that says, we're not going to bother to go back to every case that was decided under Pennoyer and tell you whether that those cases are rightly decided, because there's lots of them. But it said, to the extent these cases are inconsistent with International Shoe, they are overturned. I mean, that's abrogation. And then in Daimler and in BNSF, the Supreme Court said, cases decided in the Pennoyer era, quote, should not attract heavy reliance today.
No, but they also say that consent is not at all something that they're addressing, and they make very clear that the rules being developed in that case law is separate and apart from consent. Because you agree, of course, that a corporation could consent, like any party.
I think that's right, Your Honor, but I think what I'd say is there's consent and there's consent.
All right, so do you not think it's an open question?
I think it is I think a fair and full reading of all of the Supreme Court's cases show that it is decided. I will agree with you that there is no single
So
sentence
why
from
was there mention of consent then?
Well, because, again, I think that,
And carving that out?
right. I think what they're carving out is the true consent, the consent from things like Insurance of Ireland, where they say, if you have a contract that says, we will consent to the jurisdiction of the New York courts for causes of action arising from this contract, of course, you don't have a personal jurisdiction defense, even if you otherwise would.
Except in one of the cases, which I think it wasn't preserved, was about the Minnesota statute on consent, which is really kind of what we're talking about, as opposed to what you're talking about, which I think is not disputed. No one's disputing that.
Right, that's right. So
I'm not so sure you can limit it to that.
I mean, I think that is, I do think there is a difference between the kind of consent that is brought about, even in states where you do have consent by registration, this sort of forced, implied, coerced consent, and, the true consent that you enter into between contractual parties. And I think when the 14th Amendment cases carve out consent, what they're talking about is the second form of consent, the true consent, not this, I mean, New York has...
And are you saying, counsel, that's the difference between the Supreme Court when they say by consent versus what Cardozo was saying in Bagdon is consent? Because I think that's the crux of this argument. How are we defining consent? So can you speak to that?
I think that is exactly right, Your Honor, that the consent that's brought about, it's an implied consent, if anything. It's like the kind of consent when you say that, when drivers drive on the roads, they consent to this, that, or the other thing. It's implied by the law, I suppose, but it's not the same kind of consent that you would think of if you, I mean, it's the difference between saying that by driving on the roads, you consent to have the officers pull over, and give you a breathalyzer test versus the consent of when you say, officer, feel free to take a look around my car. The second kind, of course, isn't subject to the Fourth Amendment. The first is. Unless the court has further questions.
Is the implied consent one that, does it get any better, or is it easily fixed by a statutory amendment that just states in our registration statute that registration is consent to general jurisdiction?
I think if you amended the statute, I don't have a statutory argument anymore, but I still think I have a constitutional argument. And I think that gets, and I think Ms. Risk will address this to some extent, the unconstitutional conditions and commerce clause arguments that we have, which is that to put a company between the choice of doing business in the state of New York or being subject to all claims against all the country. I mean, my friend on the other side points out these are New York plaintiffs and New York cars and everything else. But remember, general jurisdiction is if you're somebody in Texas who has a slip and fall case against Ford, there would be jurisdiction over the companies here in New York. So that's what general jurisdiction is, and I don't think there's any reason to bring those number of cases onto the New York courts.
If I can get back to this language in Baghdad, it says the stipulation is a true contract, a true agent, consent that's real consent, contract deals with jurisdiction of the person. I mean, why is the court talking about contracts and agents if it's not the kind of consent your adversary is referring to and many scholars refer to as opposed to what you're talking about? Because the consent you're talking about is not in dispute. Parties negotiate, they go back and forth, and they agree to something. That is not what Baghdad was about. That's not what this case is about. And I'm hard pressed to see it your way. I understand why you want us to see it your way, but if the court is referring back to contracts, and what is a true contract, a true agent, it strikes me as very different from what you're trying to say.
I think because Baghdad in the Pennoyer era had to talk that way. I mean, you had to talk about agents and contracts and appointments and consent, because that's how you worked when Pennoyer was the law. And I think what International Shoe said is, those consent theories don't really work anymore. I mean, we hammered them in because that's how we thought we should do it in Pennoyer.
Why do you have to say it's a contract to say that if you're getting served within the territory of the state, within its boundaries, the courts of that state have jurisdiction over your company?
Well, I think the reason you had to do that is because of the
yeah.
awkwardness of the corporate form. It's not like individuals. Burnham talks about this. And so that's why they talked in contract language. And the innovation of International Shoe, although it also expanded jurisdiction, was to say that let's not talk about consent anymore. Like it wasn't, I don't think, entirely satisfying then because it wasn't a true consent, but that's how judges did it then.
Counsel, getting back to the language of the statute for a moment, does the due process analysis differ depending on whether the statute clearly writes in consent or by registration, or it's implied, read into it?
I don't necessarily think so, Your Honor. I mean, I think some of the arguments that have been brought up by other courts that you wouldn't know when you enter into the registration, of course, those would drop away to a certain extent. But I think actually a line from Schaefer is pretty important here, where there it was the attachment principle, where essentially that the state court would attach your intangible property that was viewed to have a Delaware situs unless you entered an appearance. And what the court said was, it said, in such cases, if a direct assertion of personal jurisdiction, in other words, separate from this attachment fiction, would violate the Constitution, then it would seem that an indirect assertion of that jurisdiction should be equally impermissible. And I think that would be my argument, which is to say that if you couldn't just reach out and directly say, Ford and Goodyear, you are subject to general jurisdiction here. Trying to do it indirectly through this mechanism of we put the consent into the statute should also be impermissible. And I think that would be true of any number of constitutional rights. I mean, if they were to write into the corporation law, by registering to do business in the state of New York, you agree that your delivery vehicles can be searched by the state troopers at any reason for any time. You can certainly consent to a search of your vehicle, but I don't think that would pass Fourth Amendment muster just because they put it in a statute. I think the same is true with the 14th Amendment.
Thank
But
you,
in your
counsel.
example, I'm sorry, Chief,
Yes.
in your example, since you raised this hypothetical, there's not a benefit you're getting, is there? I mean,
I
isn't
think
that
in
the
my
argument?
example,
Isn't that in part the Court of Appeals in Baghdad and Justice Cardozo's argument, that that's why it's a true contract, because the corporate entity is getting a great deal of benefit from this relationship, and that's why it's a consent. Because they're getting something in return.
I think in my hypothetical would be the same benefit, that if you want to do business in the state of New York, you consent to us searching your delivery vehicles at any time for any reason.
Okay, thank you.
Counsel?
Good afternoon. May it please the court, Jane Risk on behalf of the Goodyear Tire and Rubber Company. Goodyear joins in this appeal with Ford to affirm the appellate division's ruling. The so-called consent by registration is unconstitutional for a separate and distinct reason than was relied upon by the appellate division, but one that this court can rely upon. The so-called consent by registration doctrine is unconstitutional, is an unconstitutional condition. And what does that mean? The Coons Court in Kuntz, the United States Supreme Court described the unconstitutional conditions doctrine is one that vindicates the Constitution because it prevents a state from coercing people into giving up their personal constitutional rights.
What's the constitutional right you're talking about? I'm over
You're-
here, sorry.
Personal jurisdiction is a constitutional right as an individual liberty, interest, and constitutional right that was preserved by the Due Process Clause, and that's enumerated in Insurance
Right,
Corporation.
you got the
versus
right to
company.
due process before a court deems itself able to exercise jurisdiction and pull you into its jurisdiction for purposes of a lawsuit. But if you're consenting, you agree that that would not violate due process, right? It's a due process argument.
Your Honor, it is a due process argument that personal jurisdiction is a constitutional right, both of a corporation and an individual. I would agree that if an individual or...
I just want to be clear, I may be misunderstanding you. I think what you're arguing, and you correct me if I'm wrong, is that the constitutional right is not to be dragged into a jurisdiction without appropriate due process as interpreted by the Supreme Court, which is that whole international shoe analysis.
Correct. And Your Honor, the Denton's case upon which the Kuntz relies is particularly illustrative of that point. In Denton's, if a Texas state law required as a condition to doing business in the state of Texas, required that a defendant corporation give up its right to remove a case to federal court. If this case would proceed, it would be similarly impermissible. In this case, a New York law that would, as a condition to doing business in the state of New York, would stop or restrict a corporation from actually, from resisting state court general jurisdiction over all matters
Do
before.
you agree, though, that it's an open question with respect to the Supreme Court, whether or not our statutes like this are unconstitutional?
No, Your Honor, I don't believe that. I believe, and I agree with Mr. Marotta on this point, I agree in the totality of all of the jurisprudential, of all the jurisprudence from the United States Supreme Court and of the altered jurisprudential landscape since Daimler. I believe that, in fact, Bagdon has been abrogated.
But then why does the Supreme Court, carve out consent? And if you're right, they would just say, and you can't have coerced consent.
Oh, Your Honor, because there is actual consent. I mean, there are, and Your Honor spoke earlier about different types of consent being enumerated in Supreme Court cases. There are people who consent to jurisdiction every day, and companies who do also. But
Counsel,
in
can I
this
ask a
case,
question here? So I understand how this has changed with respect to a company like your client or Ford, right? Because before, even if you didn't read this the way plaintiffs would like us to read it here, and Bagdon arguably interprets it, this consent statute, you were here under the old pre-Daimler test, doing business here. You were here. Now you're arguably not here under Daimler, so this statute becomes critical to get general jurisdiction over Ford or over your client. But before Daimler, if I was a Texas company, very small Texas company, and I said, I think I'm going to do some business in New York, so I'm going to register. And I registered here, and there's an accident in Oklahoma or whatever, and the plaintiffs come to New York. Under the old Bagdon interpretation of consent, I could be sued, general jurisdiction in New York, and there was no alternative doing business jurisdiction in that case, general. Because I'm a Texas company, I'm not really here, I've registered, I'm thinking about coming here, but I'm not really here at all. So clearly a due process violation without statute, without consent. Why didn't anyone challenge the statute before?
Your Honor, you mean statute, challenge Bagden
Challenge consent, yeah.
consent?
Like, I'm a Texas company, I'm not in New York, I'm getting sued because I registered to do business thinking I might someday do business there, but that's a due process violation, absent my consent under this statute. And that's true before Daimler.
Well, Your
So
Honor-
why wasn't the statute unconstitutional then?
Your Honor, I can't say why another corporation didn't challenge Bagden or the consent by jurisdiction in the Pennoyer era, because it was a different era, it was a different way that state courts were trying to assert their jurisdiction over corporations
Okay,
they couldn't.
International Shoe comes along.
Yes, Your Honor. And
And then
international.
why didn't the Texas company challenge Bagden after that?
Your Honor, I can't say that a Texas company didn't challenge Bagden after International Shoe, because International Shoe was very specific about its general jurisdiction and continuous and systemic activities, so that amounting to presence within the state. Because remember, International Shoe still brought us back to that presence idea. It wasn't until Daimler that we got to the continuous and
No,
systemic
I
activities
understand that
to make us at
part.
home.
I guess my question is, if I wasn't president and I was a company and I was only being hauled into court in New York because of this statute after International Shoe, why wouldn't I raise this issue?
Your Honor, I think that's the very reason, because International Shoe related this to continuous and systemic activities of a defendant as to be present in the state. The major pivot came, as Your Honor acknowledged earlier, when Daimler changed that to continuous and systemic activities of a defendant so as to making it essentially at home. That's an entirely different set of circumstances and rubric. And that's when defendants did question the constitutionality under Daimler.
Thank you, counsel. Counsel, you have your rebuttal time.
Your Honors, make no mistake, Justice Ginsburg knew precisely what she was doing when she turned around and used those words, not consent. That her decision, the decisions that she penned, were not based upon consent, because consent would have raised an entirely different constitutional issue. The reason that nobody, Your Honor...
So can I stop you for 1 second?
Yes.
So we can look at this in one of two ways. I want to just tell me if you agree or disagree with this analytically. I'm not asking you to take a side on it. But in one way, we have a continuum of contacts going from Pennoyer to the minimum contacts of International Shoe to the continuous at-home contacts of Daimler, and a line of cases that deal with corporate presence in specific states, and basically you're weighing the amount of contact that you have to determine whether or not there's jurisdiction. And that specific jurisdiction, that's set up to one side. Then we have general jurisdiction, and we say you get that by either being from that place or you can consent to it. And that's a different thing entirely. Is that the way you're asking us to look at these analytically and say simply, it's not a question of the nature of the context, it's not a question of contact at all, it's a question of what you consent to in the same way that you would consent to, two parties would consent to jurisdiction in a provision in a contract to the use of New York law?
Yes, Your Honor. I think that what I'm saying and the way that I see this...
If we were to rule in your favor, then you're not looking for a discussion of contacts, the amount of contacts, whether or not you met the amount of contacts, any of that line of cases back for 150 years in the United States Constitution. You're looking for an entirely different vein that you're following, which is the consent vein, that's purely similar to the contractual vein, where we have forum selection clauses.
Well, I think the difference is the other way around, but yes. But understand...
it would be unfair to ask you where you are in it, you're for your client, but I'm just simply saying analytically, how do you see it?
Analytically, I see it, Your Honor, as almost both ways and leading to the same conclusion.
Okay, tell me how.
Because I think the contract question is easy, why it leads to the conclusion that my clients need to stay here in New York rather than litigate it throughout the country in various jurisdictions. But secondarily, after Ford Motor Company v. Montana, the world that we thought changed with the trilogy of cases took a sidestep. It said specific jurisdiction, yes, but the relationship doesn't have to be material to the incident. It's got to be relevant to the incident, use whatever word you'd like, but it doesn't have to be material. There's no causation requirement in Ford Motor Company. And if we turned around, and Your Honors have the ability to do this, and search the record, and the arguments are there in the record, my clients would have the ability to litigate this case in New York, even under specific jurisdiction. And so 2 amendments are satisfied here with the right sort of decision. And if not, one of them is going to be offended. There is no need to change Justice Cardozo and the Supreme Court's view in Nierbo and Justice Ginsburg's view about consent. It's there in this case. It's obvious. These defendants have been on the plaintiff's side of captions here in New York. They've acted just like New York corporations. If a piece of cargo comes into New York Harbor and it's Ford's and it's damaged, they sue in New York. So they've acted with all the benefit of New York corporations. And we've done that. We've done that. We've given them that wonderful opportunity to be here in the center of the economic world in the United States.
Thank you, counsel. And at this time, we'll take a break to allow the staff to execute our...
Your Honor, if I just might have a moment, please, not as a matter of reply.
I'm sorry?
Not as a matter of reply, but if Your Honor's decisions is against my client, I would just bring up the fact and make the request that Your Honor stay your decision until action on the legislative bill, because otherwise the situation would be created due to the retroactivity portion of that bill, that if that bill is signed, no reason to believe it's not going to be.
Thank you, counsel.
My client's case would have been dismissed and they would not have the retroactivity.
Thank you, counsel.
Thank you, Your Honor.